Welcome back to Legalese 123, where we are covering cases across America. Hello and welcome to Legalese 123. I'm your host, Missy K. How is everybody doing on this Tuesday, December the 23rd? Have you gotten all of your Christmas gifts? Do you still need to go out and go fight the crowds and get your last minute things? Or have you started your holiday cooking prep? I know I still haven't made any cookies yet for my kids, and well, I think I probably need to get into action. But beforehand, I wanted to bring you this case because it's been on my mind and I wanted to bring it to your attention. I've been so caught up in the Karen Reed sidebars. There's still so many volumes to go through. I've only gotten through volume 15. There's a couple more. And this is just trial one. And these are just the beginning. There's still all of trial one and then all of trial two. So stay tuned. Make sure to like and subscribe and to share if you would like to hear more content. So today we're talking about the Aaron Spencer case. I know I have some new followers, so you may not be apprised of this case. So let me bring it up here for you and tell you a little bit about this case. Aaron Spencer is accused of unaliving Michael Fosler. Michael Fosler is a 67-year-old man. On October 8th, 2024, Spencer woke up and found that his 14-year-old daughter was missing out of her bed. Their dog was barking furiously. It was around midnight. Spencer told his wife to contact 911, and he went out to go find his daughter. He found his daughter in Michael Fosler's car. Michael Fosler is 67 years old. It has come to our attention that Michael Fosler had been SAing Aaron Spencer's daughter back in July of 2024. The Spencer family found out that Michael Fosler had been having inappropriate relations with his daughter. He then was arrested. Michael Fosler was arrested, and he had 43 counts of sexual assault. Now let's go back to October. Aaron Spencer is awoken. He can't find his daughter in the middle of the night. So then he goes out looking for her. He finds out that Fosler has his daughter in his car. Spencer flashes his lights, honks his horn to get Fosler to pull over to release his daughter, but Fosler refuses to. Spencer hits the car. It ends up in a ditch. Fosler is then asked to get out of the car, and he says, F you. Aaron Spencer finally gets him out of the car and wants him to release his daughter. Spencer then sees that Fosler is going to go grab for something, and Fosler has a pistol and unloads his pistol on him. Michael Fosler is pretty much unalived at the end of the road. Spencer gets his daughter. He calls 911. The police arrive. Spencer is arrested. So it comes out that Fosler was bringing his daughter back from SAing her just that night and bringing her back to her home. Somehow or another, he allured her outside of his home and outside of her home to go with Fosler. Is Aaron Spencer justified in his actions? He thinks that he is. The state says no, that they don't. The state also alleges that the 14-year-old daughter had a consensual relationship with Fosler. So there was a pre-trial hearing motion this past Friday. And so we're going to go over, so there was a gag order on everything and nothing could be said. That was vacated in June of 2025. And so therefore now we get the full information about this case. So where are we right now? There was a pre-trial hearing set for December the 17th, and that happened. But unfortunately, in Arkansas, they don't allow cameras into the courtroom. So we have to rely on firsthand accounts as well as the account of the news media. So let's see what this article has to say. Judge allows trial to move on. Let's make this bigger. All right. So A judge has cleared the way for a high profile murder case to proceed, one involving a man seeking the top law enforcement job in Lonoke County. Oh, did I forget to mention that Aaron Spencer is running for sheriff in his town? Yep. You can't make this up. You can't write this stuff. So, yes, he's being accused of unaliving Michael Fosler, but he's also running for sheriff, which doesn't happen until November of 2026. So, if he is acquitted of these charges, he's running. In a pair of rulings issued Friday, the Circuit Judge Barbara Elmore denied a request to dismiss the case against the sheriff's candidate Aaron Spencer and ruled that prosecutors may rely on cell phone location data at trial. Spencer is charged with second-degree murder in 2024 shooting of the death of Michael Fosler. Court records state that the shooting happened after Spencer saw Fosler driving his daughter. At the time, Fosler had been released on bond after being accused of raping Spencer's underage daughter earlier that summer. Spencer's defense argued the charges should be thrown out because the case was not presented to a grand jury, citing Fifth Amendment protections. In Arkansas, they have a strange ruling that the prosecutors do not need to go to a grand jury in order to indict somebody. They can just go ahead and indict you themselves. That is a weird law in that state. In a brief written order, Judge Elmore rejected the claim, emphasizing Arkansas law allows prosecutors to bring these charges through a filed information. The judge also addressed disputed evidence, siding with the state on the use of cell tower and cell site location records, while drawing a line excluding aerial images. The decisions follow a pretrial hearing earlier this week, as the case continues toward trial, estimated to begin January 26th. So, I mean, this case is just rolling ahead. It is so steamrolling ahead. All right. So now we have some Facebook accounts from some people who have been in the trial and have firsthand account of what's happening at the events at the trial. And so these are people's opinions. These are people's whose thoughts and opinions are happening at these events. And we're going to see what their firsthand counts were going forward. Let me see if I can get these up. Okay, so here we go. We found it. So remember, these are accounts of people who were at the trial or the pretrial conference hearing, and these are their thoughts and opinions as to what transpired. Remember, the media only reports on little drips and drabs. The people that are there are the boots on the ground. These are their thoughts and their opinions. So today, pretrial hearing update number 1. The pretrial hearing actually took 2 days. They had witnesses and stuff come in and testify. So today's pretrial hearing made one thing painfully clear. This process is becoming less about justice and more about control. From the start, the atmosphere inside the courthouse was tense and heavy-handed. Security was escalated to an extreme level with drones in the air and dozens of Arkansas state troopers present. At one point, the entire courtroom was evacuated and searched over concerns that updates were being shared publicly. This unprecedented move left many questioning transparency. Judge Elmore went so far as to remove an individual from Mr. Spencer's defense team from the courtroom over a dispute involving the issue of a cell phone to research case law. Meanwhile, Chief Prosecutor Chuck Graham reportedly remained out of the courtroom for much of the day, avoiding direct participation while decisions that will shape this case are being made. Today's rulings. The court ruled on what evidence jurors will be allowed to hear, decisions that heavily favor the prosecution and limit Aaron's ability to fully defend himself. The judge denied the defense's motion to dismiss on the Fifth Amendment grounds. We spoke about that. The court allowed an FBI agent to testify about cell site location data, despite no dispute from either side about where Aaron was at the time of the incident. Prosecutors were granted permission to introduce statements and body cam footage from a 2024 police response, opening the door to emotionally charged material unrelated to the moment in question. So, what happened was back when Spencer found out that his daughter was being SA'd by Fosler, he had gone to another person who was Fosler's girlfriend at the time. He had questioned her about who Fosler was, etc. That person then reported her conversation to another person who was a mandatory reporter. She then informed the police. The police went over to Spencer's house. They had body cam footage that had the encounter. They wanted him to have his daughter file a report. Spencer wasn't sure he wanted to file a report just yet, but in that he did make a statement that asked, what if he took the law into his own hands? That was in July of 2024. We are now, the incident didn't happen until October of 2024. Let's go on. It says these rulings do not determine guilt or innocent, but they do shape the narrative the jury will be shown. What this looks like. Supporters watched today as the scales of justice appeared tilted. Key defense arguments were restricted, transparency was disrupted, and prosecutorial requests were repeatedly granted. This is how the confidence in the system is. This is not how the confidence in the system is built. What's next? This hearing is not over. It will continue into day 2, beginning tomorrow morning at 8 a.m. The defense is expected to argue for an adverse inference jury instruction related to the Lonoke County's Sheriff's Office losing the dash cam footage from Michael Fosler's vehicle, evidence that should never have gone missing. Does this sound familiar? If you're thinking, oh, missing footage, Karen Reed case, you're absolutely correct. So Michael Fosler had a dash cam. The sheriff's office had taken that dash cam SD card out of his dash cam. They might have reviewed it. They put it all back together, the camera and the SD card together, and then somehow, poof, it's gone. Aaron Spencer deserves a fair trial. What we saw today raises serious concerns about whether fairness is truly being honored. Please continue to stand with Aaron and his family. Your voices, prayers, and attention matter more than ever. So this lovely supporter came back to us on day 2 and gave us an account of what they saw. Day 2. Today's pretrial hearing in the Aaron Spencer case focused mostly entirely on the mishandling of evidence. Testimony from 4 Lonoke County Sheriff's Office deputies and a defense technology expert revealed serious investigative failures and contradictions. Multiple officers admitted under oath that they did not follow established evidence handling protocols while simultaneously asserting that compliance was not required. Key points from today's testimony include no photograph was ever taken of the dash cam. Only approximately 20 photos were taken of the crime scene, including Fosler's truck, which allegedly contained 6 SD cards. I don't know what that's about. Deputy McCain testified that he only photographed the exterior edges of the vehicle and did not enter the cab, despite the cab being lit and the dash camera allegedly glowing. He stated this is why he did not see the camera, yet testified he located Fosler's wallet under the driver's seat. Neither Fosler's vehicle nor Aaron Spencer's vehicle were processed until June of 2025. A search warrant for Fosler's electronic devices was not executed until October of 2025, at which time multiple computers, hard drives, devices, and SD cards were recovered, many of which remain unprocessed. Okay. The dash camera was not entered into evidence until October 2025 and was never photographed, logged, or documented in any report by Deputy McCain. McCain testified that he removed and reviewed the SD card, claiming it contained 4 15-minute videos showing only blue lights, but admitted he did not watch the videos in their entirety, directly contradicting his sworn affidavit. McCain further testified that he never reviewed responding deputies' body cam footage, which captured evidence and statements made prior to his arrival, admitted he violated evidence handling policy. Carla Lucas testified that she never reviewed McCain's work and therefore could not confirm whether protocol was followed. She also testified that no other evidence in this case had been mishandled. A deputy who was a second on scene testified that he informed uh, di- uh, McCain about the dash camera around 3 a.m., while McCain claimed he was not informed until 5:15 or 5:30 a.m. Records show the deputy was home by 3 a.m. Deputies testified they were instructed to turn off body cameras when CID arrived, despite policy explicitly prohibiting this practice. The dash camera and the SD card were allegedly kept in McCain's office cabinet, never logged into evidence, never photographed, and stored in a manila envelope secured only by a metal clasp. No explanation was provided for the missing SD card. The camera was later transported to the Attorney General's office by Carla Lucas. In June 2025, the AG's office reported the camera contained no SD card or internal storage. Searches failed to locate the missing card. The defense IT expert testified that the camera's software saves footage in standardized short increments and demonstrated that a 15-minute continuous video could not be recreated. He also demonstrated the SD card locking mechanism, showing it could be accidentally removed. Judge Elmore stated she will issue her ruling in January. These are the individuals entrusted with evidence collection, preservation, and truth seeking on behalf of the citizens of Lonoke County. Credit and appreciation goes to Courtney Roldan for her detailed and thorough reporting of the highlight in today's proceedings. So, this is Aaron Spencer's wife. Let's see this. This says the analysis of Aaron Spencer pretrial hearings, gun owners of Arkansas. Let's see what this has to say. All right, let's remove that. Let's see if I can bring this up. One moment, please. StreamYard doesn't like me. All right, here we go. Streaming is dynamic. All right, let's bring this to the stage. Okay, so this is from the Gun Owners of Arkansas. So let's see what they have to say. Analysis of the Aaron Spencer pre-trial hearings. The pre-trial hearings for Aaron Spencer, the Lonoke County father and sheriff's candidate charged with second-degree murder in the death of Michael Fosler, has revealed a prosecution case riddled with inconsistencies, missing evidence, and questionable relevance. From unreliable cell site data to mishandled dash cam footage, the hearings have raised serious concerns about whether the state can meet its burden of proof beyond a reasonable doubt. And that is the crux of this case, right? If it is a shoddy case and the state is going ahead and putting this forth, then there is reasonable doubt, and a jury then should find him innocent of these charges. It is sad that he has to go through this, but we do have to remember that he did unalive somebody. And some people could say, is that vigilante justice, or is it justice for the actions that Fosler took against Spencer's daughter? 4 officers and a defense tech expert testified, showing how poorly the investigation was conducted. Officers admitted they didn't follow their own protocols, but said they didn't have to. No photos were ever taken of Fosler's dash cam, or 20-ish photos were taken of the crime scene, including Fosler's truck, which allegedly contained 6 SD cards. Deputy McCain testified he only took pictures of the vehicle from the edge of the vehicle, and he did not go into the vehicle to take pictures, which is why he didn't see the glowing dash cam. Neither Fosler nor Aaron's vehicle were processed until June 2025. A search warrant for Fosler's electronic devices wasn't done until October of 2025, when multiple computers, hard drives, devices, and SD cards were found, most still unprocessed. I'm hoping they processed it by now so that they can go forward because this train is headed for trial in January. And if they don't have this discovery information, how are they going to continue? But again, I'm not there. I'm not in the courtroom. I don't get to see things. I only see some of the filings going back and forth, and it's very frustrating. It really really is because it's not just the fact that this person's going through this. This is anybody in the Lonoke County area, right? These are your police officers. It's like the same thing for Karen Reed. Those are your police officers. They're charging you of a crime. You have to go and pay a lawyer. It costs a lot of money to defend yourself. And you don't know what's going to happen. Your fate is in a jury's hand. You don't know what's going to happen. And if they stack the cards against you, are you getting a fair trial? It's all about transparency. Okay, so a case built on unreliable technology. One of the prosecution's central pillars is the cell site location data presented by a federal agent. The state argues that Spencer's phone pinged in ways that align with their timeline of the shooting, but the defense pushed back hard, and rightfully so. Cell site data can show a general area, not a precise location. Even the prosecution's own witness acknowledged the limitations of the technology. Despite this, the judge allowed the testimony without requiring satellite imagery or more robust corroboration. For a case of this magnitude, relying on imprecise technology to place a defendant at a scene is a shaky foundation at best. At worst, it risks misleading a jury. Well, it's sort of the same thing in the Karen Reed case, right? It becomes a battle of the experts. If this expert says one thing, you get somebody who says something else. They split the difference. The jury then gets to decide. So it is a case of the battle of the experts. Hopefully, they have an expert. I believe that they do. That is going to then go ahead and talk about how this information is incorrect. The prosecution also introduced footage camera from 3 months before the shooting. The footage has nothing to do with the night in question. In it, the officer tells Spencer not to take the law into your own hands during the initial grape investigation involving his daughter. The defense argued that the footage is irrelevant to the murder charge and that they're right. Emotional context is not evidence. A father expressing anger after learning his daughter was SA'd is not proof of premeditation months later. Introducing this footage risks inflaming the jury rather than informing them. Is it more probative? If the body cam footage from the 3 months prior is so important to the prosecution's case, then why were the deputies on scene instructed to turn off their body cameras when CID arrived, which they said is policy during the most important parts of the investigation? The missing dash cam footage, we talked about that. They're talking that this is spoliation of evidence. Judge Elmore stated she's making a ruling on these in January on the dash cam fiasco. A defense expert child exploitation grooming witness is being excluded from the trial because Judge Elmore stated child grooming and SA is not relevant to this case. The whole case from start to finish is about exactly that. The defense can't bring up Fosler's prior history, which appears to include that he was out on bail for the same thing that he was doing at the time. They can't talk about his grooming, his pedophile tendencies, if Spencer didn't know prior to the incident, or if it's outside this community. The bigger picture, reasonable doubt, is everywhere. The defense's position is not built on technicalities, it's built on constitutional principles. A fair trial requires reliable evidence, properly preserved records, and relevance to the actual charges. The pre-trial hearings have shown the opposite. Evidence that can't pinpoint location, footage that has nothing to do with the incident, critical video lost due to investigative negligence, exclusion of evidence about Fosler's child grooming SA history. When the state's case is this fractured, reasonable doubt isn't a stretch, but its only responsible conclusion. Again, this is going to be up to a jury to decide. Conclusion: there seems to be a coordinated effort to stack the deck against a man who protected his daughter. Again, we talked about that. Aaron Spencer's defense team has every reason to challenge the prosecution's narrative. They absolutely do. Remember, it's the defense's job to poke holes in the prosecution's case. And before it goes to trial, their job is to try to eliminate as much evidence as possible from coming in. It's the same as the prosecution. They're trying to eliminate evidence coming in. Is it more probative? Is it prejudicial? Is it character based? Is it going to say that there's bad character on Fosler because of XYZ? Again, it is an emotionally charged case. And it's also staying in Lonoke County. So you would think that the people in Lonoke County know about this case. It's a small town. Everybody's got to know everybody's business, right? So we got some really good information there. Now, I want to share with you the court documents, because the court documents are what is, what's happening. So this is about the cell site information that Judge Elmore went ahead and cited. Let's make this a little bit smaller. All right. So on December 17th, the court, having reviewed the defendant's motion to dismiss the state's response, the court, pursuant to Arkansas Constitution and the applicable state law, recognizes that individuals may be charged through the filing of any information by the prosecutor. So we kind of knew this. I kind of knew, kind of looking at it and looking at the law, that this is the law. The prosecutors can go ahead and make a claim against you, and it does not have to give it to a grand jury. So it was a weak sort of motion that they put forward to the judge, but you never know, it might stick. So that's her order on the denying the motion to dismiss. Now we have another order from her in reference to I believe this is the cell site data. So let's see what this has to say. Yep. All right, let's bring it up. Make it a little bit bigger so you can see it too. All right. On December 17th, this court was presented with testimony on cell site location evidence. The court, having considered the defendant's motion to exclude the state's proposed cell tower and historical cell site location evidence. The court also has considered ARE 403. While this type of evidence is not precise, it may assist the jury in understanding general movements or proximity during relevant time periods when limitations are clearly explained. The court will not permit testimony suggesting the cell tower evidence establishes an exact location or pinpoint accuracy. Area photographs in the cell site document provided to the court shall not be allowed. For these reasons, the defendant's motions to exclude is denied. The cell tower and cell site evidence will be admitted, subject to the limitations that it may be offered only to show general tower connections and coverage areas, not precise location. So, what does that tell us? Well, one would think that this FBI agent who testified is going to say, okay, a cell location is here, he was here, and that just sort of puts him in the general vicinity. Hopefully that's what it's going to say or do, but I wasn't in the courtroom. I can tell that it's going to state something else, but again, the battle of the experts. What does his expert say? What does this expert have to say? So, I want to remind you that there was the pretrial hearing that was set for December 17th. The trial date is still scheduled for January 26th. So a lot is going to be happening in this case between now and then. As you saw earlier in the filings or in the reports that people had coming out from the trial, the pretrial hearing, that Barbara Elmore is going to rule on some of these motions sometime in January. So they're taking a break for the holidays, which is acceptable. And so hopefully we'll hear something the first or second week of January. But this train is moving forward. And when I say moving forward, it is full steam ahead. I kid you not. This is one of the fastest cases that we've ever seen. How, who, what, where, when, how, and why, I don't know. I'm hoping that the defense has all of their discovery. I'm hoping the prosecution gets all of their discovery. I do want a swift justice for Aaron Spencer. I want it to happen quickly for him so that this can be sort of put behind him one way or the other, whether he's found innocent or guilty. I do hope that everything comes to light in this court case and that the family gets the justice that they need. So, with that being said, that is kind of where we're at with the Aaron Spencer update. As soon as we have more information, I will let you know because it is a highly contested case. Aaron Spencer's family have a gifts and go. I'm going to go ahead and put it into the show notes that if you are in the giving mood, you can go ahead and donate to their defense fund. So that is all that we have going on today in the Aaron Spencer case. Thank you for joining me. Make sure that you like and subscribe and follow for more content. We have a lot coming up. I still need to do my weekly update from last week. I haven't done with all of the cases that we're following, so I'm going to go ahead and do that on the next stream. So we'll see you on the next one. Welcome back to Legalese 1, 2, 3, where we are covering cases across America.